I would like to start this morning by just acknowledging that I have been very privileged because I grew up in a home that was financially secure. And I was a white male. And back in the 1940s and 50s, being a white male meant you were privileged. My law school class was 99 white guys and 1 woman. And that was indicative of what life was like in the 1960s. So much of what has happened to me is not as a result of what I've done, so much as it was that I was white, I was male, and I lived in a society that privileged that kind of people. And my parents were financially secure. So I think I've already covered a great deal about working on the underground, establishing the right of Columbia to appropriate underground natural gas storage easements. But one of the problems that arose in those cases was that the bright lawyers that were hired by various property owners made the claim that our gas was trespassing beneath their clients' farms, because they asked us, do you think your gas is under our property? And we said, yes, that's the reason we want to appropriate the underground gas storage easement. Whereupon they made in one of these cases, they made a claim for damages because we had intentionally trespassed underneath their property. Well, the fact of the matter is that, and the analogy I used was that our gas under a farm was about as damaging as United Airlines flying a plane over the farm, and neither should amount to trespass. And I tried that case to David Dowd, the judge that heard so many of these cases, and he found that it was trespass. And after he'd made that finding, he said to me off the record that he thought I had the better argument, but he thought it was a situation that deserved an opinion from the Court of Appeals. Now, so I went to argue that case before the Court of Appeals, and you need to remember that the Sixth Circuit is Michigan, Ohio, Kentucky, and Tennessee. So we get some judges with Southern accents. And I will never forget, as I began that argument, I said, may it please the court, and I could barely get that out. And then the chief judge leans over and says, Mr. Noble, we are not interested in your philosophical arguments. We want to know how come your client put their gas onto these poor people's property for the last 20 years and didn't tell them so. And we went downhill from there. And the Assistant General Counsel, Jack Snyder, that I worked for, they tape record these arguments. And you can buy a copy of the tape. He bought a copy of the tape, listened to the tape, and then he called me up and he said, David, did you know that those people had you up for 43 minutes? It's supposed to be a 15-minute argument, but there's a light on the podium. There's a green light and a red light. As long as the green light is on, you keep talking. And I felt like a Joe Palooka punching doll. They'd whack at me and I'd come up and I'd try to answer their questions, and then another question. It was the most difficult final argument, or not final argument, oral argument before a court of appeals that I had in my career. And ultimately, they found that the issue had not been preserved for appeal, which means they didn't know what to do with it. I mean, there's no question. the next time I saw Judge Dowd, he was just as mad as a wet hen because that issue had clearly been preserved for appeal. They needed to figure it out. They didn't want to figure it out. So what happened was we tried that issue, based on that precedent, we tried that issue in another case, and Judge Dowd issued the most wonderful 12, 13, 18-page opinion finding that it was not trespass, and to the best of my knowledge, that's the law of the land today.
So they never appealed?
No,
Yeah.
no. The landowner didn't want to spend his money.
Mm-hmm.
I think his lawyer gave him very good advice that that opinion was so well written and so carefully reasoned that there really wasn't much chance that it was going to get appealed, that they would win. Judge Dowd wrote that opinion to persuade the Sixth Circuit that that was the answer to the question, and he did just a magnificent job. Going back to my practice of law in Millersburg, I think it was 1983, the Attorney General of the state of Ohio brought a Medicaid fraud suit against the Castle nursing homes, which was there were 6 different nursing homes totaling over 500 beds, and it was one of my best clients. Now, having then the nursing home was owned by a lady named Eileen Dehas, who was dedicated to taking care of patients. That was her whole life. I had meetings with her when she was either still in bed. The offices were in a large home, and the back of the home was Eileen's home. Or she'd be sitting in the kitchen of one of her nursing homes, and she and I'd be talking about some important legal question, and she'd be peeling potatoes. And she bought 3 homes in Fort Lauderdale, near the beach, so she could take her patients to have vacations. So, I mean, she was just an amazing lady. And then all of a sudden she was accused of Medicaid fraud. Now, I understood a little bit about Medicaid, but not enough to defend a Medicaid fraud case. So I went out and found the best lawyer in Ohio for Medicaid fraud, and his name was Denny Roth, and he had a partner named Carol Rolfe, and I hired them to help me defend this Medicaid fraud case. And we ended up having a hearing. Well, first of all, I knew that a Medicaid fraud case would be terrible for the Attorney General to try to present to a jury, so I promptly put on a jury demand. And that resulted in a pre-trial. I'll never forget, where the judge down in Columbus told me that that this was purely an accounting case, and clearly was not the kind of case that a jury could be made to understand. And he said, "I really don't think you should try this case to a jury, Mr. Noble." I said, Judge, I understand your concern, but I want a jury." He says, "Mr. Noble, I don't think you're hearing me." I said, "Yes, I hear you, Judge." He says, "Well, let me explain how we do things around here." He says, you certainly understand that in Ohio, criminal cases take precedent over civil cases. The Medicaid fraud case was a civil case. This was a civil case to recover money from the Castle nursing home. And in terms of money, they wanted about $1 million for this one year. And that would have, the things they were complaining about would have gone back 10 years. So there was $10 million on the table.
Which
and
would have done in the nursing home.
it would have done it in the nursing home. It would have put them out of business. It might have resulted in a criminal prosecution of Eileen. And then the judge says, criminal cases take precedence. So Mr. Noble, we'll give you your jury. But every time a criminal case is filed in this court, that will take precedent. We will deal with the criminal case. And you and your jury will sit around and twiddle your thumbs for most of the summer as I deal with criminal matters. But in between, we'll hear your case to a jury. I said, all right, Your Honor, we will waive a jury. He said, good. I feel as safe as if I was in my mother's arms. I'm assigning this to a magistrate, which is exactly what I didn't want to have done, because most magistrates don't have the knowledge or the intestinal fortitude to do a good job. We were very fortunate. We got a very good magistrate. And the result was that at the end of the case, at the end of the state's case, we moved to dismiss, and the magistrate granted the motion.
That's pretty unusual.
That is extremely unusual, but simply through the cross-examination that was conducted by myself and Denny Roth, it became clear that the Medicaid fraud accountants did not understand what was going on at the nursing home. For example, they were all excited because costs for, Eileen had a farm, fairly large farm, and most of the costs for the farm were on the Medicaid cost report. They thought that they clearly had her. Through cross-examination, we made it clear that all of the food from the farm, the beef, the corn, the wheat, was fed to the patients. And we were keeping the costs down by having the costs. You know, we had a lot of fun with these people asking them about the food costs, because there were very few food costs. There were mostly farm costs. And by the end of the case, by the end of their presentation, it was clear that they were that they didn't know what they were doing. And the case was dismissed. Well, Denny Roth and I became very good friends, Denny and Carol, during the course of this. And Denny invited me to come practice law with him in Cleveland. And at that time, Gail was working on a master's degree at Case Western. Our daughter, Elizabeth, was dancing at the Cuyahoga Valley Youth Ballet. And I was representing Columbia Gas with increasing cases in Cleveland and Akron. And there were many a day that Gail and I would drive 2 cars to Cleveland. And then sometimes Gail would drive to Cleveland, come back, and then drive to Cuyahoga Falls so Elizabeth could dance. I mean, the amount of mileage we were putting on our cars because we were doing things in Cleveland was amazing, so it became clear that moving to Cleveland was a really good idea. So we made preparation. Gail spent a lot of time surveying school districts in Cleveland. She finally selected, she was going to move to Shaker Heights. And Rob, we were going to wait until June of '85 because Donald was going to graduate from college, or from high school in June of '85. So he would go off to college. But Rob was 2 years behind him. And so we paid some attention to what Rob had to say about the schools. And he did not want to go to a huge high school like Shaker Heights. So Gail selected the Orange School District and found a house in Pepper Pike, which is part of the Orange School District. And in June of 1985, we moved to Cleveland because these people had invited me to join them, and because my principal client was using me a lot in Cleveland and Akron.
How did it feel leaving Millersburg? You've been there, you've been part of the community.
It was difficult. And the fact of the matter is that we have maintained our friendships with the people, our best friends in this whole world are people we met in Millersburg to this day. I mean, before you came here today, I was talking to Dick Seaman. I know Dick Seaman and I became friends in Millersburg. In fact, and the Seamans have moved to Worcester, the Angelos have moved to Worcester, so half of our group is in Worcester, half is in Millersburg, and then the Roaches live in Maryland. But there's 7 couples. I'm the oldest, Gail's the youngest, that have been friends for more than 40 years because we met in Millersburg. And we have a Wooburg group. We call ourselves Wooburg because Worcester, Millersburg. And so we may physically have left the community, but we maintain ties to this day with that community. And so, but it was really quite a proposition to pick up a one-man band law practice in Millersburg, Ohio, and move it to downtown Cleveland. It just sounds like the silliest thing that ever came down the pike.
But there you are.
But there you are, and that's what I did.
Mm-hmm.
Now, when I was working with Denny and Carol, our partnership lasted about 2 years. And when we started, we thought that we would be doing mostly nursing home law. And Denny and Carol were doing almost entirely nursing home law. What we had not anticipated was that my oil and gas work would just explode. Not only my Columbia Gas work, but work for other people in the oil field around Ohio. And so we found that we had no synergy. They were doing nursing home law. I was doing oil and gas law. I needed partners. I needed some help with the oil and gas law. And I talked to them, and they didn't think we needed to hire another associate so that I had somebody to work with. So we agreed to part our ways, and I found a very fine young lawyer named John Sullivan who joined me, and we had offices on Huron Road, right next to the Halley building. We were
right in downtown Cleveland.
Right up from Playhouse Square. And we had a wonderful oil and gas practice doing a lot of Columbia work and a lot of other kind of work. And one of the cases that we tried this was a case that John brought to the office. He had been retained by some people, a whole group of people who had been defrauded by some oil and gas shysters in Dallas. And these people had invested, when you totaled up the amount of money that our clients, who literally were all over the country, had invested with these shysters. It totaled about $10 million. And we filed a racketeering, influence, and corrupt organizations case in Dallas against the shysters. I traveled to Dallas with my secretary, and we spent 2 weeks in Dallas trying this case to a jury. And in federal court, in a civil case, you have six people in the jury. One of the most difficult trials I've ever participated in. We traveled to court with, my secretary and I traveled to court with two-wheel dollies, with bankers' boxes stacked on the two-wheel dollies. And we set up an office in my hotel room that was full of boxes.
All the documentation for the case.
All the documentation for the case. She had driven my van to Dallas with all this stuff in it. And then toward the end of the case, Gail flew down to Dallas, and my secretary returned to Cleveland. And then Gail and I were we drove all the documents back to Cleveland after, and at the end of the case, we ended up with the jury was out for 3 days. Now, it was a pretty simple case. I couldn't figure out what was going on. Finally, they came. Oh, and I proved a case of $10 million. That's what I wanted. I wanted a RICO verdict of $10 million, which, if I'd gotten that verdict and the judge had done the right thing, it would have been tripled to $30 million. We would have bankrupted all of these shysters. I don't think I would have collected $30 million, but these people had a lot of money. So, but what happened was I got a verdict for $2.5 million. And afterwards, the 5 of the 6 jurors could not wait to talk to me when the case was over. And they told me that there was one juror who just would not, they said, 5 of us, when we went back to the jury room, just said, it's a $10 million verdict. And then we spent 3 days dealing with this guy who didn't want to award anything and didn't have any good reasons. He just didn't want to award anything. And we couldn't figure out what was going on. I know what was going on. He'd been bribed. I'm just certain. Now, can I prove that? No. There's no reasonable explanation for what I ran into. So I had a $2.5 million verdict. The judge called the defense lawyers and me up to the bench at the end of the case, and he told the defense lawyers to be sure that they filed motions for a directed verdict. And he told them there was one defendant who didn't stay to hear the verdict, or her lawyer. She didn't want to pay her lawyer to sit in the courtroom. He told him to tell that woman to have her lawyer file a motion for directed verdict. Directed them to do that. And then, I don't know, 3 or 4 weeks later, we got an order granting all of the motions for directed verdict with no reason whatsoever. He'd been bribed. So I was in Dallas, and what I ran into was a corrupt juror and a corrupt federal judge. That should happen, I found just... Now, can I prove it? No.
Did you ever try and investigate it?
No. And part of the problem was that I was exhausted. Financially, psychologically, it was just had me exhausted. So, and the shysters' lawyers offered to settle. I don't know. they made me, I think, about $250,000 to go away, which basically covered the costs that I had incurred going down there and trying that case and all the stuff we had done beforehand. It was, and my financial condition would be a whole lot different if I had won that case. But that's how life is. Sometimes you get beaten down and you just have to claw your way back. And the one other case that I had during my tenure in Cleveland that I think that was particularly important was another racketeering, influenced, and corrupt organizations case. This time it was Columbia Natural Resources, which was a sister corporation of Columbia Gas. Actually, it was a corporation that Columbia Systems had spun out of Columbia Gas. It was all of the production operations rather than the gas distribution operations. And there was an oil and gas promoter, I'd call him, who took a real run at trying to collect Columbia's leases, oil and gas leases, and organized different scenarios where he was trying to get Columbia's leases declared invalid, and some of the drilling practices were improper, and it was all a fraud. And and he was substantially irritating the management of Columbia, as you might imagine. And on their behalf, I filed a racketeering, influence, and corrupt organizations case against this guy. Now, Judge Scalia, in some other case, there was a piece of dicta from Scalia where he just speculated that perhaps the RICO statute was void for vagueness. The 14th Amendment right of due process requires that a person know what they're prohibited from doing. And the RICO statute's it's a little bit complicated. And so he speculated that perhaps it's unconstitutionally void for vagueness. Whereupon this promoter's lawyer filed a motion. Their response to my RICO suit was a motion to dismiss on the grounds that RICO was unconstitutional. Now, when you appeal to judicial laziness, you will likely win. And Judge White saw this motion and said to himself, watch me get this case off my docket, and granted the motion. So I had then had the high privilege of arguing before the United States Court of Appeals for the Sixth Circuit the issue of whether or not the Racketeering, Influence, and Corrupt Organizations Act statute was constitutional. And I am almost certain that the Chief Judge of the Sixth Circuit took one look at that case and said that is going to be a very, very important case, and assigned the best judges he had in the circuit. Because I went down to Cincinnati and had it was the absolute opposite of the argument that I had had in the trespassing natural gas case. In this case, it was like a law school discussion. I had a discussion with the judges And the other guy, the lawyer on the other side was a very good lawyer. And he had a beautiful discussion. I got to get up and argue and respond to what he had to say. The judges said, we'll take it under consideration. They proceeded to write an just spectacularly good 18, 19, 20 page, I don't know, long opinion, holding that RICO was constitutional and analyzing the statute up one side and down the other. And it was just wonderful. And it led to the best moment of my legal career, which happened after I had turned my license back to the Ohio Supreme Court. But one day, my daughter Elizabeth, who was at that point a student at Duke Law School, called me up and said, "Dad, your case on the constitutionality of RICO is in my casebook." It just doesn't get any better than that.